When does recklessness become murder? A car is traveling 100 miles per hour. The driver doesn't brake. Seconds later, 2 people are dead. It sounds simple when you tell the story that way, but in a courtroom, one of the most important questions may be something we cannot see at all. What was happening inside the driver's mind? Because causing someone's death does not automatically tell us what crime occurred. Imagine 2 drivers. The first is speeding. She's driving far too fast. She loses control of the vehicle, crashes, and her passenger dies. Now imagine another driver. She's angry at the passenger beside her. She deliberately accelerates toward a concrete wall because she wants that passenger dead. The outcome is the same. A person died. But legally, those cases may be very different. Why? Because criminal law doesn't look at what happened. Doesn't only look at what happened. It also asks what the person intended when it happened. That's where cases involving reckless conduct become difficult, because we can't climb inside someone's mind. There usually isn't a confession waiting for investigators that says, yes, I intended to kill this person. Instead, intent is often proven through circumstantial evidence. What happened before the incident? What did the person say? What did they do? Did they have an opportunity to stop? Did their actions continue? And what reasonable conclusions can be drawn from all those facts together, the totality of circumstances? That's where the prosecution and defense can look at the exact same evidence and tell 2 very different stories. The prosecution may say, this wasn't one reckless decision. Look at the entire sequence of deliberate actions. The defense may respond, you have proven dangerous behavior. You have proven terrible judgment. You may have proven criminal recklessness, but you still haven't proven an intent to kill. And that distinction matters, because our justice system isn't supposed to choose the most serious charge simply because the outcome was horrific. A terrible outcome does not automatically establish the mental state required for the most serious offense. But the opposite is also true. A defendant doesn't have to announce an intention to kill before a fact finder is permitted to conclude that the intention existed. Intent can be inferred from conduct, and sometimes the conduct itself becomes the prosecution's strongest evidence. So when you hear about a case involving an extraordinarily dangerous act followed by someone's death, don't stop with, did the defendant cause it? Ask the next question. What mental state did the state have to prove? Then ask, what evidence proves that mental state? Because sometimes the difference between recklessness and murder isn't found in what happened at the end. It's found in what the evidence tells us about the decisions that came before it. And that is where the real legal argument begins. This is Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney. Be sure and check out Grace and Gavel, because that's what we do. We do true crime. And if you're interested in true crime, definitely check it out. It's housed on YouTube. Grace_and_Gavel, where truth meets compassion, because we have a victim-centered approach rather than sensationalism. So if you got value in this, please consider liking and subscribing, and have a great day, and come back and see me again soon. Bye-bye.